Jay-Z's lawyer has put in multiple motions to the judge since Jay-Z was named in this lawsuit on December 8th, and the judge has not responded to anything. Jay-Z's team is trying to get the Jane Doe to not be able to remain anonymous, and then they also filed another motion to try to get this whole entire lawsuit thrown out due to the inconsistencies in the Jane Doe story from the NBC interview. Now, we've seen a lot of this play out in the media with back and forth going on between Jay-Z and Tony Buzbee, but Tony Buzbee has not filed a motion until today. Tony Busby has finally clapped back at all of the motions that were entered by Jay-Z and his lawyer. Motion filed on December 13, 2024, defendant Sean Carter notified the court of his intention to file a motion to strike and sanctions immediately under Rule 11. As with defendant Carter's prior letters filed in this case, it is historic in tone, but groundless. Defendant Carter threatens the plaintiff with a Rule 11 motion based on the question raised by one single television interview concerning events that occurred 24 years ago, when the plaintiff was 13 years old. Defendant Carter also asked this court to alter the federal rules of civil procedure in his favor by the mandatory 21-day Rule 11 safe harbor period without any legal support or factual justification whatsoever. Defendant Carter's threat of Rule 11 motion is frivolous because it characterizes the run-of-the-mill disputes of fact as proof that the plaintiff's complaint is baseless. None of the factual issues Carter identifies are significant to even grant summary judgment in Carter's favor. The fact that the defendant or a potential witness does not agree or recollect with the facts alleged in the complaint does not and cannot give a rise to motion for sanctions for filing a baseless complaint. Defendant Carter's threat of an immediate sanction motion on the first whispers of a factual uncertainty is just one more instance of bullying intended to have a chilling effect on plaintiff, the plaintiff's counsel, and any potential plaintiffs watching the proceedings. A Rule 11 motion is frivolous on the additional ground that expecting a victim of SA over 2 decades ago, and when that victim was a minor, to have a perfect recall of all facts is outrageous. Defendant Carter twists the plaintiff's words when he accuses her, for instance, of guessing at the timing of events alleged in the complaint, such as the length of car rides. New York courts have acknowledged that the plaintiff in this type of case cannot be expected to have exact recall and command of all relevant facts. He then states the law that says we recognize the matters of SA involving minors as recounted by survivors years after the fact. Dates and times are sometimes appropriate and incapable of calendarical exactitude in approving allegations spanning from a 4-year window of time in which the abuse could have occurred. There is no basis for Rule 11 motion here, and if filed, such a motion would itself be subject to a Rule 11 motion in response. Of course, we cannot prevent Defendant Carter from wasting the resources of this court and all parties in pursuing one. Defendant Carter's request that the court shorten the filing deadline for his threatened Rule 11 motion from 21 days to 1 day is entirely improper. Carter fails to cite any precedent whatsoever to support the astonishing request because there is none. Carter also fails to cite any reason why federal rules of civil procedure should be in his favor in this particular case, and again, there is none. From the outset, Defendant Carter and his counsel have maintained entitlement to different rules and faster procedures, from expedited briefing on the issue of anonymity and a summary dismissal of the plaintiff's complaint till now, and a wholesome elimination of the 21-day safe harbor Rule 11. In each instance, the goal has been to blur the facts and rush a decision, but there is aggressive advocacy and then there is bad faith. Mr. Carter's latest tactics, much like this open threat to refer the plaintiff's attorney for disciplinary action, crosses that line. Moreover, outside the courtroom, Mr. Carter has employed tactics of intimidation and harassment even more extreme, torturous, and quite possibly illegal. My firm has recently filed a lawsuit in Harris County, Texas, that details how Mr. Carter's company, Rock Nation, and his counsel have bribed my clients to file lawsuits against my firm, threatened former clients, and impersonated state officials, and have engaged in other behavior far beyond the pale of acceptable conduct. Their tactics won't work, and they will be addressed in more detail in connection with the parties' briefing on the plaintiff's anonymity. Like Mr. Combs, Mr. Carter is rich, famous, and powerful. Mr. Carter will exert all the pressure he can to intimidate and harass the plaintiff, me, or anyone else. The chilling effect of those efforts is substantial, as is the potential chilling effect of the Rule 11 motion being brought in these circumstances. Ultimately, in our court systems, the rules are the same for Mr. Carter and for the plaintiff here. Finally, Defendant Carter raises the status of my admission in the Southern District of New York. As with his previous letters to this court, his December 13th letter includes a substantial amount of defamatory suggestions about me, including that I am somehow attempting to circumvent the authority of this court to enforce Rule 11 against me. That is nonsense. I am a member of the State Bar of New York and admitted to the Eastern District of New York. I intend to apply for admission to the Southern District. The fact that I have signed pleadings and letters filed in this court does not reflect any attempt by me to evade responsibility for anything. To the contrary, I have signed those pleadings and papers because I am lead counsel in this and other similar cases already pending in this district. A lot of people were waiting for Tony Busby to respond to the multiple motions that Jay-Z and his legal team were filing about this Jane Doe lawsuit. Now he has finally responded, and it's something that we are watching very closely. Now, the judge has not responded to any motion put out at all. She hasn't said a word, so we do not know if she is going to dismiss this Jane Doe's lawsuit or if it's going to continue to move forward in a court of law. I will let you guys know as soon as I see anything, but y'all let me know what you guys think about all this in the comments.